Okay, looks like we're just at the hour here, so why don't we get started? There's a lot to discuss today. My name is Joseph Caniglio, and I'm the Director of Antitrust Innovation Policy and the Schumpeter Project on Competition Policy here at the Information Technology Innovation Foundation. I want to welcome you all on behalf of ITIF to this really great panel we've got for you, FTC v. Meta, Takeaways from a Landmark Trial. As brief background, the FTC v. Meta case represents a long-running antitrust saga, an action first brought by the Trump administration, who had its initial complaint dismissed against Meta, refiled by the Biden FTC, whose complaint survived, and now being litigated by the second Trump administration. Really a textbook example of the sort of antitrust populism that has gained a foothold on both sides of the political aisle. The FTC alleges that Facebook's over decade old acquisitions of the photo sharing app Instagram and the messaging service WhatsApp maintained an alleged monopoly in a personal social network services market, which is defined to include only four competitors: Facebook, Instagram, Snapchat, and MeWe. Needless to say, Meta contests the FTC's market definition very vigorously as overly narrow, and in particular excluding competition in social from video sharing like TikTok and YouTube. And it also contends that not only is it speculative, really, at best, to claim that WhatsApp and Instagram would have developed into very serious competitors, but that each service has really flourished and grown substantially since the acquisitions in a very pro consumer way. So, to discuss the case, I'm very fortunate to have with me really a great group of experts. First, we have Jessica Malusian, Director of the Center for Technology and Innovation at the Competitive Enterprise Institute, as well as an Antitrust and Competition Policy Fellow at the Innovators Network. Jessica's research covers a broad range of tech policy issues: antitrust, privacy, AI, telecom, and many more. And she writes and speaks widely in leading publications like the New York Times, Wall Street Journal, Washington Post. Jess, real pleasure to have you with us this morning.
Thank you.
Second, Alden Abbott, a senior research fellow at the Mercatus Center at George Mason University School of Law and advisory board member at the Antitrust Education Project. Alden has had a distinguished career in government, to say the least, from 2018 to 2021, serving as general counsel at the Federal Trade Commission, where he had previously worked in a number of senior roles in prior administrations. He also spent many years at the Department of Commerce, including as acting general counsel, and additionally as a special counsel at the Antitrust Division during the Reagan and Bush 1 years. He's also held high-level positions at BlackBerry and the Heritage Foundation, and again speaks and is published broadly on all varieties of antitrust issues. Great to see you again, Alden.
Thank you.
Third, Brendan Benedict, principal at the Benedict Law Group, where he represents clients in complex antitrust and commercial litigation. Has been recognized as a top plaintiffs litigator and a next generation leader in law by Law Dragon. He's participated in several high profile antitrust tech cases, including representing the state of Utah against Google, as well as Qualcomm in its win against the FTC. He also is a well-known commentator on antitrust, writes, speaks, and is quoted on antitrust and tech matters. And I know many of us have been reading his commentary on this case in particular very closely. So thanks for taking the time to be here, Brendan.
Thanks for having me.
Finally, Dan Gilman, Senior Scholar of Competition Policy at the International Center for Law and Economics, where he researches and writes broadly on antitrust, economics, competition policy, and more. Before joining ICLE, Dan was an attorney advisor in the FTC's Office of Policy Planning. And before that, taught law and economics at University of Maryland, Penn State, and Washington University in St. Louis. Dan is really a prolific commentator, and his regular blogs on Truth of the Market are really must-reads for all who are interested in antitrust policy. Dan, welcome.
Thanks very much, Joe.
Well, why don't we kick it off here? And Dan, why don't you start us if you would? So obviously, big part of a Section 2 case, necessary predicate is to show monopoly power. And as I mentioned, we've got a couple big issues here on the relevant market the FTC's defined, market shares, as well as questions like entry, right, and pressures put on by other competitors. So why don't you lead us off? What are we looking at on the monopoly power issue?
Well, I think as you mentioned, it's an element of a Section 2 case at the highest level. There's both possession of monopoly power in a relevant market and the willful maintenance of that power as distinguished from some sort of natural growth or development as a consequence of a superior product, business acumen, or historic accident is the language we have in one of the Supreme Court cases, Grinnell. Um, so one thing to notice is that this is a Section 2 case, right? It's not a Clayton Act Section 7 case. Had the agency sought to block one of these acquisitions or both of them at the time they were screened, presumably they would have acted under Clayton Section 7, not under Section 2 of the Sherman Act. So that's one thing. As an aside, not a trivial aside, both of these acquisitions were scrutinized by the FTC, were screened by the FTC. No complaint was ever filed. Staff didn't think that there was a good reason to challenge either one. I mean, Instagram was one of many photo app sharing apps. They had 13 employees. They obviously had some potential, but they weren't then and aren't now the only photo sharing app. WhatsApp, barely in the U.S. at all as a messaging app, and of course there are other messaging apps. So we want to get to monopoly power. Why do they want to get to? They want to get to monopoly power as an element of the case. How do they get there? They get there, number one. I think we'll probably talk more about market definition here, but you're trying to establish monopoly power in a given market. So there's the market definition. Then there's how you establish monopoly power, directly or indirectly. And then there's the question, what do you do with it? Well, I think we'll probably talk more about market definition. It seems to me to be gerrymandered, not just narrow, but gerrymandered. So it's sort of largely based on the brown shoe factors, which are, to be fair, not overruled really, but disfavored. By no means the best way to do this, as many have argued, Herb Hovenkamp and others. Some of them are just plainly wrong. They're sort of mushy and amenable to all sorts of futzing about. We have much better methods now. Then there's this weird counting, right? So as you mentioned, we have these very few competitors. They're not doing any economic tests. They're sort of defining it on certain features, not just functional features available to consumers, but how Meta, initially Facebook, implements those features, like a specific kind of social graph that enables friends and family sharing. And then, of course, Scott Hempel wants to count only sharing of things on those specific for platforms, but not only the things that they pick out, right? So anything you do on Facebook counts, even if it's not part of this friends and family sharing, even if it's something that's done on all these other platforms, and nothing you do on X, TikTok, on a different platform outside the four counts, because it's not in the market. So it's a very weird calculation. I don't think that there's any good economic grounds for it. It seems to me to be a combination of a gerrymandered market definition and sort of sleight of hand and counting to get you to high market shares. Now, of course, high market shares themselves are not unlawful. We can talk about that. I'm sure I've gone over my 3 minutes.
No, that's okay, Dan. Appreciate that great overview of the case. And Brendan, I want to turn it over to you. Dan mentioned some of the issues that I think Judge Boasberg noted in his summary judgment opinion with how some of these market shares were counted, specifically excluding friends and family activity on platforms that like TikTok, YouTube outside the market, and then including non-friends and family activities in the market. So, what were some of the ways the FTC maybe tried to grapple with that, and otherwise some of the best evidence it put forward on the monopoly power issue?
Yeah, so maybe I think it's helpful to start with the second part of that first as an overview, and we'll come back to that other issue. It's just as you said in the intro comment, it's a proposed market of personal social networking services. And the theme that really got developed over the course of trial, and I was attending every day, blogging about it for the Big Tech on Trial Substack, was this friends and family sharing use case that people go to find out updates about people in their lives, not in a professional capacity, but in a personal one. And that's what they use Facebook, Instagram for. Chief Judge Boasberg said at one point in the trial that the fight on market definition, it's not really about, kind of ticky tack potential competitors like LinkedIn or Twitter or Pinterest. Meta has this broader view of market definition, of course, that kind of takes into account what they say is a two-sided aspect of the platform, the advertising side. And if you think about things that way, it's a competition for time and attention, because the more time and attention you have on the consumer side, the more you can monetize by selling ads on the advertiser side. So the fight really comes down to, are TikTok and YouTube part of the market? And how does that affect market shares? I think that Meta has to win, that really both are in the market to get to a place where market shares are low enough not to raise, not to make it plausible that there's monopoly of power. That takes market shares down to something like 30%. If just TikTok is in the market, Meta's market share is 60%, which I think could be enough. It's a little bit less than a prima facie case of around 2/3 market share. But there's plenty of case law out there that says that depending on the market, 60% could be enough if there's really high barriers to entry. So that's sort of how I see things at the 20,000 foot level. On the point about having it both ways, counting the non-friends and family sharing time I guess excluding the non-friends and family sharing time when you're looking at Meta's apps and trying to not focus on short form video from competitors. I think what Scott Hemphill, the FTC's economist, the way he dealt with that is just to say that we kind of don't look at these other products. Once you have a monopolist where some of the you've defined a relevant product market around one product, you don't kind of look about other products that the monopolist is selling outside the market. And that's one way I think to think about this broader view of competition for time and attention. There is this use case of friends and family sharing. What's happened in the last few years, especially since the pandemic, is that users are spending a lot more time on Facebook and Instagram to consume short form video. And if you think about short form video as a product, well, there is lots of competition for that from TikTok, from YouTube, from all the ways that you can consume that content. And Meta keeps arguing that as a share of time spent, friends and family sharing has declined on Meta's apps. But the FTC points out that absolute time spent on friends and family sharing hasn't declined. And that, I think, paints a picture that just shows that people are spending more time on Meta's apps overall. Most of that additional time is for short form video sharing, but it's not really coming at the expense of that core use case of friends and family sharing. And I think that's where the FTC is effective. And I think Meta hasn't done a good job of showing that other apps are really competing on that core use case. But it does depend on kind of, not thinking about the other time and other products that the monopolist might be offering.
Thank you, Brendan. Very, very helpful. Alden, I want to turn to you and sort of, I think, continue the chain here. So, Dan, Brendan, they focused on the indirect case, right? Market shares, market structure, based on the FTC's relevant market. But obviously, there's other evidence that is important here. You can look at direct evidence, prices, quality output. And then also some economic evidence that was discussed in the trial, especially the TikTok outage, which I know was a big focus. So curious to get your thoughts in response to what was said on the monopoly power issue, but maybe also the relevance of those other types of, let's say, natural experiments or direct economic evidence on the monopoly power issue.
Okay, well, I think one interesting thing is platforms evolve. and indeed, certainly in TikTok, YouTube have evolved and have increased their offerings. And I think one thing that isn't clear is where exactly is you're not dealing, for example, with a large steel company with a huge, supposed capital barriers to entry. You have already a number of major networking platforms that have changed their features and adapted their features, and there's lots of friends and family time and non-fed friends and family time on these other networks. So I think it makes it very difficult to argue that, well, this is the market. The market, this is the type of industry, dynamic industry where things evolve. And again, particularly we could get to that later, but where is the harm? Where is the economic evidence, for example, that, output, look at the benefits. Meta made WhatsApp free. The output for Instagram grew from less than 9 million to 230 million US monthly active users under its watch. And Facebook also remained free to consumers despite Meta's addition of new features. Instagram as well. So what you're talking about, you are talking about great efficiencies of integration that have benefited consumers. Indeed, I think it was a study even before this full integration by Professor Brynjolfsson that said that consumers were getting hundreds of billions of dollars in consumer surplus not directly paid for. These are the benefits. So are these, I think, A, you don't have, I say it's unclear that what the market will be. B, it seems clear that huge benefits have been bestowed on consumers. And again, the question is harm. The problem about sort of advertising load and as being harmful. That wasn't, I don't think Judge Boasberg necessarily was convinced. I mean, Meta argued that their business model relies on user engagement and clicks, which leads to purchases instead of simply maximizing number of ads displayed. So if you view the number of ads displayed as a degradation in quality, it's not clear what that means. It also needs to be remembered that a monopolist has no duty to have a certain degree of quality. It, in fact, created a lot of aspects of its user experience. And even if it were monopolist, where is the duty is there a duty? No, I don't think there is. That has to have a certain degree of quality, because how is this exclusionary also? Well, this degradation of quality sort of harmed it. Well, how did that affect entry? Why could not, if there was a degradation of quality, people could switch to other products, which again suggests it didn't have a monopoly share, and the question becomes irrelevant. So I think there are lots of uncertainties here that make it very, very difficult as compared to the traditional heavy industry monopolization case, both in terms of the market definition, market shares, and even assuming the monopoly, the question of consumer harm. We don't know in the but-for world what the measures of quality would be. Again, very different than the traditional heavy industry monopolization case.
No, thank you all. And that's very helpful. And I mean, in addition to the price and the quality issue, I think there's also the quantity issue and the question of output, which is very instructive here. When you see the output have increased on Instagram and WhatsApp so much, right? That's another way of getting at that. But Jess, I want to turn to you on the monopoly power question. So we've heard a lot. What do you think are the sticking points here, and maybe some of the key issues that might move this in one way or another?
Yeah, I mean, I think we've heard a lot of the meat here already, so I'm going to keep it quick. But I'll just say, as far as the market definition, I mean, I think it just doesn't pass the common sense test. I mean, this is like saying that McDonald's has a monopoly on Big Macs. I mean, yeah, it sure does. We've narrowed it so much for the purpose of winning here, that it just sort of defies people's experience with how they're making decisions online, I think, and where they're spending their time. And I think, to Alden's point, these things are not set in stone. This is a dynamic, and especially dynamic, industry, and we're moving away from that friends and family stuff, as Meta has said. And I just think, if you're not including TikTok in the relevant market, I don't know what to say to you. I mean, in the time since this case was filed, TikTok has become like the #1 social media app in the world. So to say that there's some barrier to entry, and maybe if you make up categories in a courtroom of, well, not for this, but for that. I mean, come on, like this is just silly. With multi-homing, people are not, you don't have to sign your life away to use Instagram to the exclusion of TikTok or YouTube or a lot of other that just, again, in a common sense way, are clearly competing for people's time and attention online. And you can follow your friends on all of those, or you can look at strangers doing fun videos on all of those. So I just think at some point it's hard to get over that initial hump of that market definition for a skeptic like me.
No, thank you, Jess. Very helpful. And I do want to move now to the question of harm, because, as was mentioned, in addition to the monopoly power issue, if the FTC is going to win this case, they need to show that these transactions are actually anti-competitive. We've already gotten to a lot of those issues surrounding entry and repositioning and other things. So, Brendan, why don't I start this one off with you with respect to the Instagram transaction? I mean, I think this is certainly, I think, generally accepted, the stronger of the FTC's two claims. So what is the best evidence, let's say, the FTC, you think, put forward on why this particular transaction was anti-competitive?
Yeah, and before I touch on that, I'm reminded that at trial, in regard to your last question, this issue of how do we count time spent, and is all the time spent on Meta's apps friends and family sharing? There's actually a prorated market share calculation that Scott Hempel did, which tries to address that issue, and market shares come to 69%. So this wasn't actually a big focus at trial. So proceeding on the assumption that there is a relevant defined market and there's high market shares in that market, I think the Instagram story is the stronger of the two stories. There's some, lots of compelling emails, I thought, from the time of the acquisition. The big one is where Mark Zuckerberg seems to agree that the purpose of the Instagram acquisition is to, quote, neutralize a potential competitor. Of course, he walks that back, and we don't know why, in a subsequent email where he says, "Oh, I didn't mean to say that we wanted to take out a competitor. We wanted to grow Instagram and make it into a wonderful thing." So somebody talked to him and cleaned up that email. But the court has kind of made it easy for the FTC to show an anti-competitive effect from the acquisition at step one of that burden shifting framework, where it says that, things like reduced output or increased price are really downstream from the acquisition of a nascent or actual competitor, which is an anti-competitive effect in and of itself. So all the FTC has to do at step one is to just show, was Instagram a nascent competitor? And I think it did that. And I think emails from Mark Zuckerberg to that effect explain it. And I think one thing that was really fascinating about that is Mark Zuckerberg's a really smart guy. And you sort of never see emails like this from senior C-suite executives at public companies where they write using the language of economics. A couple times he referenced network effects, and he explained how really there's a race to be a monopolist in a particular mechanic or use case on a mobile app or a kind of website. And he thought that Instagram had sort of cornered the market on that kind of mechanic of point-to-click photos, which Facebook was really behind in at the time. So I think you put that all together, he's really making the FTC's case for them in the way that he wrote his emails. And I don't think that, his attempts to kind of put distance from himself at that trial were all that credible. I think they were more pretextual. So I think, at least on the point about acquiring a nascent competitor, I think the FTC showed that. I think looking at other effects, the best place that the FTC did to show reduced output was there's this rivalry then after the acquisition happens about 6 years later, where Instagram and Facebook are competing for the same resources. At one point in 2018, Mark Zuckerberg cuts off Instagram from using Facebook servers, its tools, its people. And Facebook's head of marketing, Alex Schultz, actually testified that that slowed Instagram's growth by about 14%. So there's a lot of back and forth about how Instagram maybe grew more quickly after the acquisition. But I think it's hard to say that any other strategic acquirer would have shot Instagram in the foot and hurt its growth by 15%, really out of some sort of, sibling rivalry between the apps. But again, I don't think the FTC even needs to show that the way that the court ruled a summary judgment.
Brendan, thank you. I think you've teed up all the right questions there, and I want to throw it next to you, Alden. So a couple of things. So under Section 2, is evidence of anti-competitive intent to exclude a competitor sufficient to shift the burden to the defendant under some sort of rule of reason analysis, or do you need more? And I think another interesting question, what's the but-for world here? Is the but-for world, if Instagram had been acquired by the transaction, is that how we should measure harm? Lots of interesting issues to tee up, please.
Yeah, absolutely. First of all, I think one of the confusing things in Section 2 cases is a reference to intent. As Judge Easterbrook has said many times, you find also, and obviously Zuckerberg is a CEO and made intelligent comments, but I think it's there in countless cases you find statements by executives who have large market shares and at times of acquisition regarding their competitive hopes and saying that objectively what happened. And I think the real central problem is what was still unresolved, I think, by the trial's end, causation. So, I take what Brendan said, but there was certainly a tremendous growth of Instagram. Could the FTC demonstrate that competition consumers would have been better off if the transaction had not occurred? As Meta explained, much of the growth was a result of Instagram being able to benefit from distribution resources Meta provided, including headcount. Yes, Meta adjusted things in 2017, but its own assets. It has a right to readjust its platform normally as it might want, I think, to optimize its use. So the FTC's only expert admitted in the end, we just don't know what Instagram would have looked like in the agency's alternative reality. I think there's a quote along the lines of, it might have been smaller, it might have been bigger. And I think in a but-for world, how this all would have played out, we don't know. And so that should not be good enough, because I think, again, the finding of the actual intent really merges into an actual objective finding of effectuated intent, of actual facts. And I think that it's a problem, particularly, remember, this was a merger and acquisition of a complement. Traditional economics have said acquisitions of complements tend to increase welfare by putting the complements together. You actually create great value for consumers. That's precisely what happened within Instagram. And if you start second guessing every acquisition, there are countless potential nascent competitors. Ex ante, one really doesn't know, especially if you have a few employees. This was the case here. Is this competitor going to amount to anything or not? And basically, you're built on this very flimsy hypothetical that in the but-for world, they might have been bigger and more successful. Then again, is equally perhaps better able to speculate that their distribution would not have been as good, that they would not have grown as fast, that fewer consumers would have benefited from their service. I think that's where we are.
Alden, thank you. Jess, want to turn to you, and then Dan, I'm coming right your way. So we discussed the causation issue, but I think it's worth drilling down on some of the pro-competitive benefits here too of the transaction. I mean, yeah, sure, any company may have squabbles as who's going to get what resources, but I think it's pretty hard to argue that Meta has poured tons of money and tons of resources into this company. What do you think?
Yeah, I think that's exactly right. So we can say, we don't really know what would happen in the but-for world. that's true. Who would be closest to being able to tell us? I think the guys that sold Instagram to Meta. There's your answer. Did they want to keep it in scale? They didn't. They sold it to Meta and they were thrilled. In everything they've said about it, they have only positive things to be. So to pretend like, oh, like Zuckerberg came in the night and wrestled Instagram away from them is outlandishly insane to me. I mean, these guys didn't, not every founder wants to scale or can scale. That's not what they want to do with their time and energy, or they don't have that ability. That's okay, right? It's okay if that's what they want to do. And it's okay to sell your glitchy, goofy, but full of potential app to someone who has the technological know-how, the resources, and the scale to make it something that now, before 9 million people were enjoying, and now 230 million Americans enjoy. So, I struggle to find, back to, the harm question, who is hurt here? The people who are enjoying a better, improved, better distributed Instagram, or the people who made money selling it because that's what they wanted to do? I just, I know there's like emails that sound mean, but to me, that's just not enough to spend this much of government resource looking into. What were Mark Zuckerberg's feelings when he wrote the email? I would imagine, like most captains of industry, his feelings are terror of being taken over by nascent competitors. And I don't think that worrying about that or noticing that and trying to make a plan to improve your product for consumers to react to that concern should be something that we automatically assume is unlawful.
Jessica, thanks. Dan, over to you. I know you have a lot to say, so
yeah, I mean, there's a sort of dance in and out of different arguments in the FTC case. So, look, all right, they acquire Instagram, they pour a lot of resources into Instagram. Instagram grows, Facebook gets some functionality from Instagram gets some functionality and installed base from Facebook. Then at a later point in time, there's some squabble over the allocation of resources. And I mean, so what? Presumably, FTC is not now arguing what nobody in the building wanted to argue in 2012, and that is that this is a killer acquisition, right? That they bought this nascent competitor so as to shut its doors and get rid of this. They did not go on a tear buying all of the photo apps out there. That would have been quite a project. Some of them are still around. Some of them are still popular. I have to say, I am on Facebook. I'm I guess nominally on Instagram as an amateur photographer. I don't especially like Instagram. Sorry, Meta. But so what? This was not a killer acquisition. Instagram has grown tremendously, both in users who seem to enjoy it, but also in functionality since the acquisition. So is Facebook charging more for that? No, they don't charge at all for it. I mean, they don't charge. Meta doesn't charge at all for Facebook either. Well, then they want to talk about advertising, the advertising market. Are they trying to run a two-sided platform market, or are they trying to argue against these acquisitions in the market that they've defined? Well, they don't. They certainly don't want to evaluate this under Amex terms, because then they have to look at the net. So it's this dancing back and forth. I suppose, on the intent thing, I guess I'd say two things. One is intent is not an element of a Section 2 violation. Intent can be pertinent to understanding other things. It's not entirely irrelevant. But the problem with hot docs is that C-suites say the darndest things, and we kind of want them to. We want people in C-suites to say all sorts of things. We don't want them all to be filtered in their business decisions through antitrust counsel. And so, can say things like, we got to kill this threat. Well, what exactly is the threat? Was this really the corporate intent? Was this really the effect? I can tell you a lot of different stories, right? Meta, then Facebook collectively saw that this mobile transition was going to be really key. And, they were worried about the pace of developing their own market leading qualitative app. And so they went on the market. They could put a lot of money into something that was already out there. And that's what they did. Is that anti-competitive? I want to look at the effects. I'm most inclined to look at output and price. We want to look at quality effects. Well, quality effects alone, and they talk about ad load, I think it's very, very complicated for all the reason courts tend to think that qualitative effects alone cases are very complicated. And the answer is there are lots and lots of qualities to things. And sometimes we can agree that there are dominant qualities. You know, you're doing a hospital merger, you have good reason to think that certain measures are going to go the wrong way, post-op infection, post-op mortality, et cetera, like if you have these things and you have no decline in price and you have no increase in output, maybe you've got a pretty good qualitative concern. So like, you know, in Phoebe Putney, where they sign an agreement with some of the big payers in the area, we're not going to raise your prices for this amount of time. Well, then you see quality effects, and everyone agrees that these quality effects are serious and terrible. Ad load, do I love seeing more ads? If that's the end of the analysis, I don't, but it's not, because the functionality changes, the quality of the ads change, everything I'm getting in return changes. And in fact, all of the alternative platforms are making their money off of advertising too. They're not running a two-sided platform case. I'm not sure why we look at that, but I mean, has ad volume even decreased? Not really. And am I worse off? I don't have a clear argument there, and they don't have any clear metric there. I think it's a lot of hand waving, where really the economic argument is not very good. And I mean, I'm sorry, we can go back and pick apart pick apart Scott Hempel's different metrics, but I that it's not good analysis. I don't see anything credible about that. I know he's a smart guy. I know who he is. I mean, no, I don't see the consumer harm here. Staff didn't see likely consumer harm at the time. Going back and unwinding these mergers, I don't see the point, unless your point is we don't like Meta, we want to harm Meta.
Dan, thank you.
Consumers are going to pay for that.
I'm sensing another blog coming on Truth on the Market on Hemp Hill, so I'm looking forward to reading that when the time comes. But moving on to WhatsApp here, and I would just invite our audience, if you have any questions, please do put those in the chat. So, my sense of this discussion, the Instagram acquisition is, I think, very similar to what we've heard in the press, which is, they acquired somebody that may have posed a threat, but real hard time showing that on balance consumers were harmed given all the benefits here. But with WhatsApp, I think we even have a real threshold issue here about showing where was the real competitive threat from this messaging service to social media. I think that's something worth talking about. So Alden, why don't you start us off here? What are the problems with this one, maybe?
Oh, okay. Well, so again, we'll go back to a nascent competitor that they argue was reasonably capable of impeding Meta's monopoly, principally by looking at a few documents by Meta executives. Again, the documents, as I said earlier, I think about intent, you're really looking at objective effects, and the term intent really as applied in cases, not subjective intent. But in any event, the intent to the real problem here is a testimony, I think, made clear WhatsApp never really had the incentive or ability to expand into a friends and family social media service in a way that could have challenged Facebook, any more than iMessage or many other messaging services that have not transformed into social players. This gets back into, barriers to entry. Well, no, I mean, I think there are lots of other apps of messaging services out there that could and have been used, but they just have, there's no reason to believe that WhatsApp would have been this miracle worker that would have been the optimal and increased welfare more than the welfare that was, again, increased because Facebook used lots of resources, I think, to promote and WhatsApp, and as I and many other people know, have used it successfully. And it gets back to the big picture question about Section 2. There's no requirement that you have that the monopoly should have the optimal welfare effects, that they should maximize welfare. The concern is they can engage in exclusionary effects that harm consumers by preventing competitors from coming in. But the idea that, well, in some hypothetical world, welfare might have been even higher, even though you have other companies out there and there's no reason they can't compete, is just not what monopolization is about. In effect, you become an engineer or a market engineer, which is not the role of government. If you try and say they could have, in some theoretical world whose probability we can't estimate, have had even higher welfare. And I've suggested the many benefits of the increased welfare associated with these acquisitions are already apparent.
Alden, thank you. I really think that hits on a key point. If this were a Section 7 case, we'd be asking questions like, was the merger the best way to accomplish these benefits? But it's a Section 2 case, and anybody who's read the Microsoft case, I'm sure you all have, knows that there is no least restrictive alternative test right under Section 2. We don't ask those types of questions, so that's very important. But Jess, turning it over to you on WhatsApp, what are your thoughts here on this? And I think Alden made a good point, right? I mean, why did WhatsApp have the special sauce, right? That iMessage and all these other players didn't. I mean, the FTC and the monopoly power stage, they told us all about the barriers to entry, right? That were so great, but now all of a sudden WhatsApp was going to overcome that. What do you think?
Yeah, I mean, I think just the starkest evidence I can give is that when Meta bought it, it made it free. It wasn't free before, and then it was free. So, to me, call me old fashioned, but that's some pretty solid economic proof that there is not consumer harm happening. And again, the larger framing of this is just the multi-homing. I don't know about everyone else, but I have iMessage and WhatsApp, and it's not. I think in a world of ones and zeros, and in the case of social media and communications, infinite supply of content, you have a different relationship with this. Like, what supply are you monopolizing? What are there? It just seems to be more of a pie to be enlarged than a pie to cut up. So I think for me, I'm not going to go much past. They bought it and they made it free to users. I'm going to rest my non-legal case on that.
Jess, thank you. Dan, turning it over to you here. I mean, talk about WhatsApp, but also I want to tie it back to Instagram and really this issue of causation standards, right? I mean, what is the right causation standard here? And is it different maybe for Instagram and WhatsApp? I mean, maybe WhatsApp really was a true nascent competitor and they benefit from a lower causation standard. Even if Instagram was an actual competitor, maybe you need to show but for there. What do you think?
Well, so it's a little weird. So the story about, I think Jessica and Alden are right about WhatsApp. I mean, there are hardly anything they charged money we can reel off. Here's an iPhone. I've got iMessage, Google Message, been around a long time. Discord, Signal, Lines, Kik, Skype, WeChat. I mean, no shortage here. You Slack at work. The causation standard, I mean, people point to Microsoft. Microsoft's a complicated case. And I think, we might do well to look at some of the things. I mean, I've written about this. All kinds of people have written about this. I think we might do well to look at what Doug Ginsburg has written with Cornwall. Or even Doug, I mean, obviously was the chief judge of the DC Circuit at the time Microsoft was decided. And so, right, we have this so-called edentulous standard for causation with a nascent competitor. But the language there's a little complicated, and I think it obscures something, which is that, key to the Microsoft decision, at least as Doug seems to think so, and I think he's better informed than I am and most people, were, the 20 some odd pages of findings in Microsoft about concrete harms done to the nascent competitor that did not seem to pass what you could call an economic sense test, a no economic sense test, right? These were things done to raise the rival's cost that didn't, apart from that competitive effect, make sense for Microsoft. Were they right about all these findings of fact? We could go one by one. Those were the findings. And so the story was, look, it's a little hard to know how much of a competitor the nascent competitor could have been, but these are the kinds of things that definitely harmed their ability to compete, right? And because of that, and because they're the kinds of things that would have done this harm to an actual competitor and to competition, that therefore we're going to lower this causality bar in a specific way. And it's not causality of harm to their ability to compete, it's what harm to competition was caused by this. And so for one thing we can notice is it's kind of a poor fit to the circumstance where where WhatsApp was not crippled. Instagram wasn't crippled either. Where where the ability of these functions to compete wasn't damaged. The functions didn't disappear from the market. And so what exactly are we asking of causality here? I think the causality standard stands, and I think the Rambus case tells us, the same circuit told us several years later that Microsoft was the special use case and that causality is the general expectation. They're supposed to do things that harm competition and consumers. I think they have to show it. I'm not sure why we should give them the edentulous test. It seems a poor fit here, and I don't think the government wins anyway. So I guess that's my take on those issues. Teasing apart Microsoft's complicated. I've written on this. Many people have written on this. We could get into the weeds, but that's my basic take on it. I don't see them being able to skate here. I don't see why they should, right? I mean, why would we, the people, why would the courts, why would the agencies be terribly concerned to unwind mergers more than a decade old in each case if the mergers didn't cause harm to competition and consumers? Why? Because we we can get away with it in a district court? I mean, I don't.
Dan, thank you. Very, very. I mean, I think that's exactly right. And but Brennan, I want to turn it over to you. And we've dumped a lot on the FTC here. What are some things they might point to try and save this claim based on trial evidence?
Sure. So I do agree. I think this is the weaker of the two stories, but their theory is really that WhatsApp had the potential to be a competitor, sort of by inference or analogy to the other chat apps that are prominent in Asia, like WeChat and Kakao, where their growth model was they started as a simple, OTT, over the top messaging service. And the reason why those were blowing up at the time, remember, this is a decade ago, was you were under some plans, some carrier plans around the world, being charged on a per message basis to send an SMS text. So sending unlimited text on a messenger just over your internet connection was a big deal. So that's how they got people in the door. And then they branched out into more personal social networking type services where you can have a profile, you can have a status, and it becomes a super app that has a lot of different functions. So that's the theory. And I think that it just didn't hold up in the proof because, they had Brian Acton, one of WhatsApp co-founders, say we were never going to do that. He testified at trial. We were never going to branch out. We were never going to monetize with advertising. I think another part of the FTC story is how viable was WhatsApp going to be in the but-for world if it didn't get acquired. And there were some issues there with its monetization, where it had basically a a dollar price payment if you bought the app on iOS. It was kind of a freemium subscription model from Android, and that wasn't going to cover its costs. And so ultimately, it would have to pivot to advertising. But that story got shot down too by Acton, by Sequoia, even by Meta itself. So I think that if we think about it, and I don't think it's just intent. I think what the court said at summary judgment was intent is probative of whether, in fact, these apps were nascent or actual competitors. But even the intent story, I think, kind of falls apart there because Zuckerberg realized, they're not in our lane. I will disagree, though, on the idea about least restrictive alternatives. That the court's summary judgment opinion said that the defendant, Meta, would have to show that the efficiencies here are merger specific, that they use the least restrictive alternative for achieving the pro-competitive benefits. We can argue about, I think, how widespread that is in the law, but I think there's some support for it. And so, taking a step back and thinking about Instagram too, it's a different case when you think about it as Meta's burden to show that those pro-competitive justifications wouldn't have been achieved by some other strategic acquirer, couldn't have been done if the apps just stayed independent. That's kind of a different case, and that's why I think the FTC has a better case than a lot of folks are making them out to have.
Brendan, thank you. Even on the least restrictive alternative point, though, I mean, I agree that's going to be a big issue if this gets appealed. But even in Section 1, I think it's usually the plaintiff that has a burden to show on that. So it'll be interesting. But I think that's a great summary of WhatsApp, really. And, just one of the things I've always just kind of found a little humorous about it is, how many years later after the acquisition it's still not even in the relevant market, right? It's such a threat they can't. But anyway, we've got about 10 minutes left here, and I want to kind of focus more on the policy implications of this case. We've already discussed some, the idea of what this means for merger enforcement more generally when you can challenge deals that are so old. Jess mentioned how much money the government's pouring in this case, and what kind of remedy might they even get out of it? And tied in a question we've got from the audience, which is, how does this sort of tie into the administration's broader strategy about, if they do get a victory in this case, what might remedies look like when we're thinking about promoting American firms and having them succeed abroad? The question we had talked about WhatsApp and how it's been very successful overseas, right? So, Jess, why don't you lead us off here on the policy implications?
Yeah, so I think looking at, the realities in the market right now is that being acquired is just in the DNA of this industry. That's just how Silicon Valley works. If you purchase, as some of us might have for our work, venture capital for dummies, in venture capital for dummies, it will tell you don't go into a venture capital meeting without a list of the companies that will possibly acquire your startup, because after Sarbanes-Oxley made IPOs that much more expensive, the exit that is now most charming to investors is that they will be acquired. This is just sort of the meat and potatoes of how Silicon Valley works. And it's a very virtuous cycle. These guys get paid out, they go back, they do another startup. This is how consumers get just a shocking amount of innovation from Silicon Valley that you don't see anywhere else in the world. So if you inject uncertainty that we can go back in time infinitely and undo these deals, it's like just a little more brakes on venture capital for these entrepreneurs. And especially in the international context. So let's say, you get rid of WhatsApp in the world. What country's company steps in to fill that void? We could talk about that too with the divestiture stuff of Chrome. This is a foothold in complicated areas around the world where U.S. tech is winning. That has national security implications. I'm obviously not the one in charge of what America First is. We've had that clarified by the president, but I would say that is not putting America first, hamstringing our companies. So I just wanted to pull back and talk about sort of what that means in the market and what that means sort of on a national security front. Beating up our own companies, we don't need to do that. Europe already does that for us. So I think there's a real inconsistency with pursuing a lot of these cases and then screaming about America First to Europe.
Jess, thank you very much. Dan, over to you. I don't want to keep harping on causation. Tell us what you think, but it's like, suppose the FTC wins on this reasonable capability theory, right? And we also have language in Microsoft that says if you want a divestiture, you need to show but for. So is there a world here where they maybe win this case, but they don't get a divestiture?
Well, there's certainly a world. I mean, in the Microsoft case is, I think, the poster child for this, because the Microsoft case is the one that sort of established this special case, maybe some people want to argue not so special case standard with respect to, causation. But it is the Microsoft case that came back and said, hey, look, on remedies, we are going to look at this. And I think that makes good sense. I think, I think that's a problem in not just this case, but in other cases. So, for instance, in the Google search case, where I think Judge Mehta got that wrong, but it was certainly a thoughtful, careful opinion. It's not just a careless or a silly botch. I think the mistake there was the bifurcation of the case into liability and remedy phases, and I think that sort of obscured the question: what's a good and defensible remedy? So, I don't. I mean, Judge Boasberg has nodded sort of in different ways in both directions. He's a smart judge. What's he going to do here? I'm pretty confident in my analysis of the case, but that's not a crystal ball as to what any district court judge is going to do. Even a smart and experienced district court judge, I don't know what he's going to do. I think it's very weird, or would be very weird, to come back and argue so many years later for divestiture. I mean, for one thing, if you spin off Instagram, Facebook can retain all sorts of functionality that they've gotten from Instagram since 2012. I mean, it's been a while. WhatsApp was 2014. Maybe they'd be viable, maybe they wouldn't be viable, but so what? It's hard for me to see that competition and consumers would be so much better off. And as far as that goes, I mean, consumers are not hurting for. I mean, whether we're talking about photo sharing apps or whether we're talking about messaging apps, consumers are not hurting for alternatives. They're not failing to use alternatives. Many of them multi-homing, not all of them. Some of them favor others. So I think the causality. I think, Joe, you're right to point to this question. Precisely because Microsoft, that gave us the so-called edentulous standard on causality, reminded us that this doesn't that this pertains to liability, not remedy. So what's the remedy? And I mean, coming back to the policy question, what's the remedy that it's going to make competition and consumers better? And how well do they know, apart from just making up a story? I'm not going to speculate on the international things. I think they're real considerations, but they're, in a sense, considerations above my pay grade. I don't know how to fold them in to industrial organization work. I don't know how to fold them into antitrust analysis, except maybe in the sense that if you think you can win on liability, don't just go for the jugular in a poorly justified manner on remedies. But that's sort of something I would say anyway. So I'm gonna leave this to the people who make those kinds of calls.
Dan, thank you. Brendan, your thoughts on the remedy policy issue, and I guess as the litigator on the panel, maybe if you give us what are the chances here, probabilities? What do you if you had to put a weight on it, who do you think is going to win this one?
Well, I'll take that second one first, and I think it's easier to say that I think the odds are low that the FTC wins on the WhatsApp story. I think there's a fighting chance on Instagram. I think a lot is going to depend on all the things we talked about whose burden is it? Is there a least restrictive alternative at step 2? And some of that is going to get resolved on appeal. So it's difficult to make a calculation, but I think it's closer to 50-50, but I think for all the problems that we've talked about, it's just not a clean case for the FTC to win that you can really hang your head on. A lot of that is just because there's no price. And so the traditional tools like a SNP as part of the HMT, you just can't do in a case like this. And that just makes stuff hard. So that's sort of the overall view, but I think the FTC is a fighting chance, and it's a lot closer than folks think. On remedies, I think the divestiture is the natural remedy. If we look at case law post Microsoft around the country, where you can go broader than the theory of liability to undo the ill-gotten gains. There's not a higher standard of proof because we trust competition in the but-for world would have resulted in better outcomes, even if you can't prove them. But I think the more interesting thing about remedies is this settlement discussion that was reported on by the Wall Street Journal before the case went to trial, where the FTC was demanding $30 billion to avoid trial. And it's not clear based on what. It's a zero price market for the consumer. The FTC doesn't have disgorgement authority to get monetary recovery anymore. There's no damages claim. Is it a civil penalty? So I think that raises some concern for me that, even though this was prosecuted in a bipartisan way across administrations, now, maybe Chair Ferguson is coming for his pound of flesh because he's been a big critic of platforms that censored conservative views. So I have concerns as a practitioner that something other than the merits is kind of driving the remedy calculus here. And I think that's unfortunate because I think the FTC team, the staff attorneys did as good a job they could on this record litigating this case. And I think the American people deserve, antitrust reasons for the remedy, not political ones.
Brendan, thank you. And I apologize to everybody for going a little bit over here, but I want to make sure we get Alden's thoughts on the remedies. So two things, Alden, turn it over to you. So one of the, Dan had mentioned, and Jess as well, the idea of divestiture after so many years. And one of the aspects of this case that I think is not discussed enough is the state case against Meta, where you had a judge say that a divestiture wasn't permitted because of latches, an equitable doctrine. So how might that play in? But also, given the concerns we've heard, about this case from a policy perspective, I mean, if there's anybody on this panel who I think can give us that America First view, it's probably you, Alden. So take it away.
Okay, well, first on latches, as a legal matter, latches cannot be imputed against the United States based on public policy. There's a bunch of Supreme Court decisions that say so, but de facto, the sort of the fairness concerns and the harm concerns associated with trying to unscramble the scrambled eggs are serious. Yeah, you could pull them out, but I think there'd be great potential harm to consumers, and for future improvements as being part of the Facebook ecosystem could be sacrificed. I think Herb Hovenkamp said it best, talking about both Google and Facebook in the 2024 article. Said there's no good way to come up with an engineering mechanism for breaking up Facebook or Google. Only thing any of those remedies does is make the platform less valuable. It won't hurt users. It won't hurt investors, stockholders, and employees, but it won't do any good in terms of making that particular set of markets more competitive. Close quote. I think if this went to a court of appeals or so on, Professor Hovenkamp is cited more by far than any other. He's Mr. Antitrust, many federal judges. I think there's almost a zero chance that a breakup, that an effort to break up, I don't know about the probabilities of, what Judge Boasberg is going to do, but I think the probabilities of a breakup are infinitesimally low. I think, as America First point already, I think made by Jess, I said, look, it puts the United States in a difficult situation when you have sort of crown jewel companies, and Donald Trump said this in last October about not wanting seemingly to break up Google, but you have these crown jewel companies that are under assault. I think separate the issue about First Amendment issues about their editorial policies that should be looked at separately. But there are real problems with in terms of America First. When you sacrifice, you disincentivize capital markets, disincentivize firms from being formed and getting the VC support so they can be sold off. I don't think this is a good good for the competitiveness of the United States.
Alden, thank you. I see we're already 5 minutes over, so we're going to have to wrap it there. But I want to thank each of our panelists for really an excellent discussion. It's a very complicated, again, long-running case, but I think we've hit on a lot of really the major issues. And we're just going to have to wait and see how this one plays out. So thank you all again. Also, thank you to everybody who tuned in. Please continue to follow us at ITIF and all the great work that is being done by our panelists on these issues. And we hope to see you again. Thank you.
Thank you.